In its advisory opinion of the 9th of July 2004, relating to the legal consequences of the construction of a wall in the occupied Palestinian territory, the International Court of Justice recalled in paragraphs 74 to 76 the position of the Security Council in respect of the city of Jerusalem. The court noted specifically how the Council, in Resolution 298, advanced, and I quote, "All legislative and administrative actions taken by Israel to change the status of the city of Jerusalem, including expropriation of land and properties, transfer of populations, and legislation aimed at the incorporation of the occupied section, are totally invalid and cannot change that status." Mr. President, the actions undertaken by Ataret Kohanim early last week in demolishing the Shepherd Hotel cannot, therefore, much as Ataret Kohanim may seek otherwise, change the legal status of East Jerusalem as occupied territory, or, to put it more succinctly, cannot turn it from territory that is non-Israeli to one that is. And however strenuously it may justify its actions in supporting the settler agenda, the Israeli government is virtually alone in the world in recognizing these actions by Ataret Kohanim and other groups like El-Ad to be lawful under, it would have us believe, a combination of Israeli military and administrative law. And yet the applicable law in respect of the exercise by Israel of military control over the occupied Palestinian territory is clear. It is not Israeli law that reigns supreme there, but international humanitarian law applicable to all high contracting parties, as well as obligations that are erga omnes. Israel's administrative and military regulations insofar as the West Bank is concerned must therefore be utterly consistent with the Fourth Geneva Convention and its control guided strictly by its obligations as the occupying power. The ICJ's position on this very last point is unambiguous. It maintained in paragraph 78 of its 2004 opinion that, and I quote, "The territories situated between the Green Line and the former eastern boundary of Palestine under the mandate were occupied by Israel in 1967 during the armed conflict between Israel and Jordan. Under customary international law, these were therefore occupied territories in which Israel had the status of occupying power. Subsequent events in these territories have done nothing to alter this situation. All these territories, including East Jerusalem, remain occupied territories, and Israel has continued to have the status of occupying power." It also merits noting there are no territorial exceptions to this finding. All the territory of the West Bank, as described by the court, is considered occupied. A closer reading of Security Council Resolution 242 also bears this point out, as we explained before the ICJ on the 24th of February 2004. In his oral submission, the late Sir Arthur Watts, QC, counsel for Jordan, noted how Resolution 242, and I quote, "affirmed unanimously the principle of Israel's withdrawal of its armed forces from territories occupied in the recent conflict, and that meant, and could only mean, territories on the non-Israeli side of the Green Line. Thus, the Green Line is the starting line from which is measured the extent of Israel's occupation of non-Israeli territory. Originating in 1949 as an armistice line, it became in 1967 the line to the Israeli side of which Israel had to withdraw its forces, and on the non-Israeli side of which territory was occupied by Israel." It is also perhaps worth our recalling how in negotiating the draft to what became Resolution 242, the understanding reached between the principal interlocutors was for withdrawal from all non-Israeli territory with only minor reciprocal border rectifications. Mr. President, for decades Israel has been settling on territory that does not belong to it, and against the wishes of the Palestinian people to whom the territory does belong and who yearn for their freedom. While it is now readily accepted the settlement policy can only be undone through a negotiated agreement between the Palestinian Authority and the Israeli government, for the latter to offer holding talks with the Palestinian president while simultaneously allowing groups like Al-Ad and Ataret Kohanim to continue their usurpation of Palestinian lands under the veil of Israeli law, the very imposition of which is ultra-virus, is contemptible and not becoming of a people who themselves have historically suffered greatly at the hands of others. That settlement building has continued unabated over the many years is true, notwithstanding the rising chorus of indignation on the part of the international community toward it. Yet there was hope a comprehensive peace could be secured before it was foreclosed altogether by the growth in the number of settlements, and that hope is being extinguished fast. Why? Because even if its legal status cannot be changed, so near are we to seeing East Jerusalem sealed off from the rest of the West Bank from the cumulative effect of both the separation wall and the actions of the settler movement, all supported by the Israeli government, it will shortly simply not be believable to us that any future Israeli government could reverse it. For even if there were to be a peace deal struck between Israel and the Palestinian Authority, requiring Israel to cede East Jerusalem, will there be an Israeli government willing to implement such a deal and be prepared to go to war with its settler community over the latter's increasingly entrenched position in East Jerusalem, no matter what other occupied territories Israel has withdrawn from in the past? And if there were to be no negotiated settlement over Jerusalem, because the settler organizations will have rendered through their actions the point moot, then the peace we all desire, a comprehensive peace, a just and durable peace, will have been murdered by an unavoidable circumstance. And Israel will be alone to chart an impossible course for itself in de facto control over an Arab population soon to be in the majority. And if those individuals on the right in Israel believe in more noxious measures for addressing the reality soon to be staring them in the face, the international community, specifically the International Criminal Court, will possibly have a say in the matter too. Mr. President, the actions of the settler movement in the occupied Palestinian territory must therefore be stopped, and the deep suffering of the Palestinian people must be brought to an end through the establishment of their own state on the basis of the 4th of June 1967 borders, with East Jerusalem as its capital, living side by side with Israel in peace and security. When the Security Council held its first session on the 17th of January 1946, the very horrors of the Second World War, including the Holocaust, were freshly in the mind of its members. If there was one objective it had to fulfill in the future, it was to preclude the recurrence of the sort of wars that left much of the world in ruin twice in the 20th century. 65 years and 2 days later, that objective remains as relevant as ever. The Council must therefore show itself strong enough to diffuse and overcome those spinning winds which, through their centrifugal forces, will draw countries, indeed whole regions, into a single colossus of an emergency, quite beyond anything we see today. A single violent shock in the heart of Jerusalem could, for example, achieve this on its own. And for the Council to simply wait for it to occur is hardly adequate preparation for what gigantic consequences will surely flow from such a transformational event. The Israelis will occasionally say to us, resolving the conflict is less a matter of law than psychology, and given the rhythms and the very real traumas of Jewish historical experience, they are cautious about placing their trust in anybody, let alone, they say, in us, the Arabs. And perhaps we must concede we could have done more to better understand this point, done more to develop greater trust by, inter alia, better explaining the terms of the Arab Peace Initiative to the Israeli public. On the other hand, the actions of states must also be guided by the rules, which this Council itself must uphold. Our deep opposition to the policy of settlement building and our repeated strong condemnation of it, which we reiterate today, is not founded on some form of primordial enmity or bigotry toward the Jewish people, and any assertion to that effect is itself thoroughly distasteful to us. What it is built on is a continuing 3-decade-long violation of international humanitarian law as confirmed by the International Court of Justice. In paragraph 120 of its 2004 advisory opinion, the ICJ held that, and I quote, "As regards these settlements, the court notes that Article 49, paragraph 6 of the Fourth Geneva Convention provides the occupying power shall not deport or transfer parts of its own population into the territory it occupies. That provision prohibits not only deportations or forced transfers of population, such as those carried out during the Second World War, but also any measures taken by an occupying power in order to organize or encourage transfers of parts of its own population into the occupied territory. In this respect, the information provided to the court shows that since 1977, Israel has conducted a policy and developed practices involving the establishment of settlements in the occupied Palestinian territory contrary to the terms of Article 49, paragraph 6 just cited." And the court continued, "The Security Council has thus taken the view that such policy and practices have no legal validity. It has also called upon Israel as the occupying power to abide scrupulously by the Fourth Geneva Convention and to rescind its previous measures and to desist from taking any action which would result in changing the legal status and the geographical nature and materially affecting the demographic composition of the Arab territories occupied since 1969, including Jerusalem, and in particular not to transfer parts of its own civilian population into the occupied Arab territories." The court went on to remind us that the Council reaffirmed its position in resolutions 452 and 465. The court concludes that Israeli settlements in the occupied Palestinian territory, including East Jerusalem, have been established in breach of international law. I thank you, Mr. President.
I thank the representative of Jordan for his statements. There are still a number of speakers remaining on my list for this meeting. I intend, with the concurrence of the members of the Council, to suspend the meeting until 2:30 p.m. The meeting is suspended.